Hello and welcome to this webcast by the Scottish Law Agent Society on risk management and the costs and expenses of conducting a case for under £3,000, which runs to proof under Sheriff Court simple procedure. So that's the topic of the talk today. Um, Essentially, it's to do with low value simple procedure cases running to proof, and I'll be looking at the issue of costs and expenses, and I'll also be looking at COVID as well. Um, I'm not going to be looking at cases which settle. A lot of simple procedure cases do settle and should settle, of course, but I won't be looking at those. There's a whole load of authorities on the issue of expenses in such cases where someone lodges a tender, how that impacts on the question of expenses, but I won't be looking at that. I'm not going to be looking either at simple procedure cases for more than £3,000. In other words, the old summary cause type case. I should say as well that an awful lot of cases under simple procedure are undefended and proceed. They now will proceed under civil online. Soon, in fact, that will be mandatory. And many of these cases are not defended. I won't be looking at those. I'll only be looking at the cases that go to proof. And as I said, I'll be looking at coronavirus as well, because it would be completely bizarre if we didn't take it into account the impact that legislation has had on expenses and procedure and practice. So, by way of introduction, my name is Andrew Stevenson. I'm a solicitor advocate and I'm a partner in the Glasgow based firm Hennessy Bowie. I've been a court lawyer since the early 90s, first conducted a proof in 1992 in front of Sheriff Jardine in Glasgow, and I've been conducting proofs, debates, appeals, all manner of civil hearings since then. I've conducted many proofs in the Sheriff Court. I've conducted a proof in the Court of Session, and I'm a contributor to Green's Litigation Styles and Green's Civil Practice Bulletin, and I've given various talks over the years on civil practice and procedure. The last proof I conducted was at the beginning of 2020. Under COVID, I've conducted debates. I've conducted a bench of three appeal by means of video conferencing. And before COVID, I certainly used video evidence, live TV links to take evidence in the course of proofs, and also in a commission that I conducted where the witness was in New Zealand and we used a live TV link to take his evidence, which was very effective. Anyway, this webcast is provided to SLAS members only and qualifies for CPD, but only under certain conditions. Anyone can view this, and there's no password or code or anything of that nature to prevent you watching this. However, to qualify as CPD, Scottish Law Agent Society has to verify your attendance, and they'll do that only if you're a current member. So if you do want CPD, as well as hearing about costs and expenses in small value simple procedure cases, you will need to join the Scottish Law Agent Society. So if you're not in that category, if you're not a member, I would suggest you stop watching, join, and then come back and watch, and you can claim CPD. Now, going back to the topic of the talk, I've used the term proof rather than the term hearing, simply because lawyers know what a proof is. Hearing can cover a multitude of types of calling. The term hearing, insofar as it applies to simple procedure, is the term that's used in the rules. Now, these are the Simple Procedure Rules of 2016, which came into force in November of that year. The concept of simple procedure already having been introduced by the Courts Reform Scotland Act of 2014. Procedure, as I'm sure you know, is aimed at party litigants. And that explains why so many of the rules are framed in colloquial terms, in a question and answer format, and why there's so much bad grammar in those rules, which some of us find irksome, but nevertheless, it's aimed at party litigants, so there's bad grammar in there. Nothing we can do about that. The other point about simple procedure is that recoverable expenses are so bad, so low, that there must be there a clear intention to try to deter at least some litigants from employing solicitors to represent them. Interestingly, when I looked into this, I noticed that in Dobie on Sheriff Court Practice, at page 12, there's a discussion about the old small debts statutes. And Dobie says that the original policy was to discourage professional pleaders. This was in terms of the Small Debt Scotland Act of 1837. And he says that it wasn't, in fact, until 1889 that remuneration to solicitors was recognised as falling within party costs. And even then, the duty was laid upon the sheriff of selecting cases in which a party may have the privilege of being assisted by a solicitor. So you can see that in the early Victorian period, they really didn't want solicitors appearing in the small debt code. And the fact that they couldn't recover expenses if their client were to be successful kind of reinforces that was the policy. Nowadays, simple procedure claims to be, and I'm quoting here, speedy, inexpensive, and informal. Now, that's quite commendable. However, in my experience, none of those adjectives applies to the vast majority of simple procedure causes. To me, and maybe it's just my experience, but the procedure seems to me to be slower than it was under small claims procedure. And as for the claim that it's inexpensive, I think that is very misleading. Clients who see that and come to you and think that the whole case is going to be conducted inexpensively, they think the whole thing is going to be cheap. I think they need to be disillusioned of that idea, and quickly, because unless you agree to do the work for a fraction of what you would ordinarily seek in terms of your costs, your fees, it's not going to be inexpensive. And I just think to myself, why should you undertake the work for less than you would ordinarily charge, given that the risks are the same? You're running the same risks of SLCC complaint if the client isn't happy. And to take on these risks, you should be remunerated properly, in my opinion. Similarly, the notion that the procedure is informal, I think, is a bit of a trap. As a solicitor, in my opinion, the last thing you want to be is informal in how you conduct any of your business. Because, of course, you always have to cover your own back. And informality, I don't think, lends itself to that. If the sheriff wants to be informal, fair enough. But the idea that we should conduct cases informally, I think, is a bad idea. So, speedy, inexpensive, and informal is the description of simple procedure. Um, Giving you my views on that. Going back to the question of your fees, in the context of litigation, if a case does proceed to proof and the parties are legally represented, the position about recoverable expenses is such that, at least under normal circumstances, the solicitor is not going to be adequately remunerated unless the client forks out considerably from his or her own pocket, or the solicitor takes a hit for whatever reason, maybe because there's other business to be had from that client, or the work's being undertaken in bulk and it could be economic to do it in that volume, whatever. But generally speaking, it's not economic for a solicitor to get involved in a case that proceeds to proof under one of these small value civil procedure cases. So maybe I should start by looking at the court fees structure itself. But before I do that, let me just look at the rule about the hearing, the proof itself. Well, the starting point is part 12 of the 2016 rules, and this is headed the hearing, which, as I say, means proof. And the most relevant bit is Rule 12.6, which asks the question, how will evidence be given at the hearing? And we're then told, before evidence is heard, the sheriff must explain the way the sheriff has decided to consider evidence. It then says the sheriff may impose conditions on how evidence is presented or dealt with, including conditions on how witnesses are questioned, or setting time limits on how long witnesses may be questioned. It's then said that the sheriff may ask questions to the parties, not questions of the parties, which I thought was the appropriate way of articulating it. It says the sheriff may ask questions to the parties or witnesses. Now, some of this is not new. Sheriffs have always been able to ask questions if there's a matter needing clarification. But taken as a package, it's clear, I think, that the purpose of this rule is to have what amounts to a partly inquisitorial role for the sheriff. And the problem, I think, with that is that it doesn't sit well with our adversarial system. There's no doubt, I think, that the sheriff is meant to be more inquisitorial. The Sheriff Appeal Court, in the case of Cabot Financial UK Limited against McGregor, which was heard along with two other cases, it's reported on the Scottish Court's website, it's a 2018 case. They said in that case that the court's powers do appear wide and constitute, in effect, a more inquisitorial and proactive approach, which is certainly the impression that one would get from looking at the rules on the matter. However, if the proof were wholly inquisitorial, that would be one thing. If it were wholly adversarial, as it would be under ordinary cause procedure, that's fine as well. Everyone would know where they stand. Where they would stand is that sole responsibility for presenting the evidence would rest with the solicitors or the parties. The problem with this halfway house created by Part 12 of the rules is, in my opinion, rather unsatisfactory and a bit risky as well. And it can lend itself to these situations that we all come across, where there aren't clear lines of responsibility. It's one of these situations, a bit like, you've heard the story about how Spider-Man says, or maybe it's his uncle who says, that with great power comes great responsibility. The problem here, I think, is that as a solicitor conducting simple procedure proofs, you could well be in a situation where you have all the responsibility if it goes wrong, but you don't have the power. You can't control the proof, but you find yourself in a situation where it doesn't go your client's way and he or she's blaming you for that. So there aren't clear lines of responsibility, in my opinion, when it comes to conducting these kinds of case. Um, the other problem I think here is one of timing, in that the rule doesn't seem to me to say that the sheriff has to tell you how he wants to conduct the proof until after you've already prepared for it. The rule really should say that the sheriff tells you how it's to be conducted before the hearing is fixed or at the point when it's fixed, not, as it does say, before evidence is heard, because you could be in a situation where you are ready to start the hearing, the proof, you cite a particular witness, you turn up, or you switch on your computer screen, ready to get going. And the sheriff then says, "Well, I don't want to hear that witness. Don't need to hear him." Or you've already made arrangements to have that witness there. That's not satisfactory, in my opinion. So there are these weaknesses, in my view, as a result of the wording of the rule. Um, it's framed in a way that lends itself to a proactive approach by the sheriff, but from a risk management perspective, I think that it means that you need to cover yourself if things go awry and the client thinks it's your fault. The way to do that, in my opinion, is to explain to the client at the outset that this is the prospect, the possibility. That's how these proceedings are governed by the rules, and that these risks exist. So then at least you're warning the client at the very outset. Having said all this, in my own experience, I have found that a so-called hearing under the rule does proceed pretty well along the same lines as a proof under summary cause procedure or small claims procedure. So my approach is to uh, prepare for a case on that basis, have a strategy, and prepare along the lines of the strategy, but also to make it clear to the client the ultimate control rests with the sheriff. So my advice would be treat the case, treat the proof like a standard proof, and don't ever rely on the sheriff to do your job. So never ever rely on a sheriff to bring out your client's evidence or cross-examine the opponent's witnesses, for example. Um, Shrivel Pro activity can be quite a good thing from a risk management perspective, insofar as that if the sheriff is controlling the proof, that does take some of the responsibility off your shoulders, so that if the sheriff stops you leading evidence, says he doesn't need to hear um, corroboration, which is something that's happened to me before, um, then your client loses. You can legitimately defer the blame away from yourself. You can say, "Well, I tried to lead this evidence or call this witness, but the sheriff didn't want me to do that." So that's my approach to these things. Have your own strategy for how you want the proof to run, as if it were a conventional proof, and try to adhere to that if you can. Now, I'm aware that conventional is not really apposite at the moment, and that's because of the prevailing coronavirus situation. The coronavirus legislation, if you've looked at it at all, you'll realise it's complicated, it's changing, and in some ways it's not entirely clear how it operates. But I will look now at the coronavirus legislation because it's obviously something of monumental importance at the moment. The legislation has obviously created enormous challenges for everybody, and you don't need me to tell you that the courts at the moment are disrupted, staff are on furlough, offices are shut, people are having to get used to working remotely in ways that have never happened before. The spread of the virus at the present time is unpredictable. The rules are having to change as we go along to balance the protection of public health against making sure that the justice system doesn't grind to a complete been standstill, or that a vast backlog of business doesn't accumulate. Justice delayed is justice denied, I think they say. So um, these are all these are the problems that we're having to deal with at the moment. The main statutory provision that applies in relation to civil courts, at least, is the Coronavirus Scotland Act 2020, Section 5, Schedule 4, which apply to justice. That's the heading that's used, justice. And paragraph 2 of the schedule states that any requirement, however expressed, that a person physically attend a court does not apply unless the court directs the person to attend physically. As far as proofs are concerned, in my view, this means, amongst other things, that if you cite a witness to attend court, that witness does not require to attend the court. Unless somebody tells him to, unless the sheriff says that he must attend court. That, in my view, is unlikely to happen as matters stand, because compelling somebody to go to a court building, or indeed most buildings, is putting him or her at a risk that he or she would not have to take or face if staying at home self-isolating. However, of course, that's not the end of the story, because paragraph 3 of the schedule says that any person must instead attend before the court by electronic means in accordance with any direction issued by the court. Subparagraph 6a says that the court must give parties an opportunity to make representations before it gives a direction. So, the way in which this translates into practice, in my view, is that you need to check quite early that witnesses are able to appear electronically, that they have internet access and understand how the technology operates. Don't assume that everybody does. The witness could be a vulnerable witness. So check the logistics so that you can make representations before the sheriff issues a direction as to how the witness is to give evidence. This requirement, this suspension of the need to attend a court physically, is all intended, of course, to deal with this unprecedented public health emergency. If you look at Schedule 4, where these provisions are to be located, you'll see that it's given effect by Section 5, which is in Part 1 of the Act, the 2020 Act. And in terms of Section 12, Part 1 was due to lapse on the 30th of September 2020, unless the Scottish Ministers made regulations extending it to 31st of March 2021, which they did. The Coronavirus Scotland Act's Amendment of Expiry Dates Regulations 2020, which is Scottish Statutory Instrument 299 of 2020, was made on the 24th of September and came into force on the 29th of September, which is the day before this part of the Act was due to lapse. So we now have an extension to the end of March, and a further final extension is competent as well until the 30th of September 2021. That's competent by a similar mechanism. Whether that happens remains to be seen. Of course, it depends on how serious the health risk is at that time. I wouldn't be surprised if it's extended again, but we'll see soon enough. There are several points I would make. The first one is that this suspension of the requirement of physical attendance is clearly supposed to be a provisional measure in light of COVID. It's not meant to be permanent, and in my view, this suggests that it's recognised that this is not the best system. Witnesses having to give evidence by video conferencing doesn't provide evidence as good as having somebody 20 feet away in a witness It's not as easy to judge demeanour. The medium that you're using diminishes that level of personal communication. You don't pick up on body language as well as you would if the person were in the same room as you. Um, I've conducted hearings using video link, and it's not all bad by any means. It's good in terms of the time and the cost savings. Um, in my view, although there are pros and cons, the fact that physical distancing is in legislation with temporary effect is an indication that proofs are likely to revert to a norm of physical attendance once this pandemic is over. Although remote attendance may well be more common in future, even when we're through the pandemic, purely for economic reasons. And one has to say, video link testimony is better than an affidavit, not least because you can't cross examine an affidavit, whereas with video conferencing, cross examination is perfectly straightforward. Another point I would make is that the way in which proofs will be conducted during this lockdown is not going to be the same in every case. Um, I was reading very recently that the first post-lockdown proof in Perth Sheriff Court was a hybrid proof in that the pursuer and the agents were in the courtroom, defenders' witnesses were giving evidence via a video link. Um, so you can see that in a simple procedure proof, there should be a discussion between the parties and the court to find a pragmatic way of hearing the proof. And I think that's why the rules specifically say that there should be a chance for representation to be made before the court issues a direction as to how witnesses give their evidence. Another point I would make is that when you cite a witness to attend court, now you're essentially asking that witness, telling that witness to be available by electronic means. And in my view, you have to spell that out in a covering letter. And you also have to explain what's required of the witness, because you can't expect him or her to know. So, what explanation do you give? Well, I think that what you have to do is you have to liaise with potential witnesses as early as possible. And this is another aspect of the kind of front-loaded preparation that's required for civil procedure cases. So you have to liaise so that the witness understands what's expected and that attendance by electronic means is to be in accordance with the direction to be issued by the court. Simply, well, one reason would be, I suppose, that the witness shouldn't be taken by surprise when that happens. As to the logistics of how it takes place, well, you have to check the guidance issued by the Sheriff Principal of the Sheriffdom of the court where you're litigating in case there's requirements in there. In an ideal world, there would be uniformity across the 6 sheriffdoms in Scotland. But of course, we're not in an ideal world, and there are discrepancies between the different sheriffdoms. So you need to check. Bear in mind too that the guidance changes. There have been changes in every single sheriffdom since the lockdown started at the end of March of 2020. And there will be further changes. So you have to keep up to speed with these. So for example, in the sheriffdom of Grampian, Highland and Islands, there's guidance from the Sheriff Principal dated the 11th of June, providing amongst other things that all hearings not requiring evidence are to be remote, and that those that do require evidence are to be remote as far as possible. And Clause 10 states that parties are responsible for ensuring that witnesses are able to appear remotely. In a sense, that's quite a tough ask. I appreciate that it has to be the responsibility of parties to do this, Because, I mean, for one thing, you can't very well have the bar officer go into somebody's house to usher the witness in front of a computer screen. Um, on the other hand, you can't do that either. Um, if you look at the Sheriff Principal guidance or some of the guidance, you'll see that there has been a drive for increased case management in general, in ordinary actions as well. And the use of a nominated sheriff to deal with a case is quite a common thing now. My view of it is that the use of a nominated sheriff is a good idea, unless perhaps the sheriff takes an obvious dislike to your client at an early stage. Um, that can happen. It can happen in family actions, particularly in my experience. But generally speaking, it's quite a good idea because it assists with efficiency. For one thing, you're not having to explain the background every time the case calls. And it may also help the sheriff, or it may help if the sheriff who is hearing the proof is the same sheriff that's been dealing with the case throughout, because he or she has the opportunity to give you directions on how he wants the evidence to be heard, having taken into account the background to the case. It's easier for the sheriff to make a direction about that. And that, of course, can take place at a point, excuse me, before you start preparing for the proof. I've said already that you have to take into account protecting yourself against claims and so on. And I always say that this is the most important consideration. Um, it's the most important consideration, whatever kind of legal work you're doing. You always have to protect yourself personally against the risks that are inherent in doing any kind of legal work. And court work is risky. Um, there are matters over which you have no control. Simple as that. And you have to try and minimise the risks. Running the proof itself is probably easy, but insofar as if you've done the preparation properly, things tend to run as smoothly as they can. Where you get problems is if you haven't done the preparation properly. The issue here about preparation, though, is kind of intertwined with the whole issue of expenses. And one of the matters about which I want to talk is the question of expenses, because it's crucial for a number of reasons, and it's something that you really need to consider and discuss with the client long before you step into the virtual courtroom, because there is a significant risk management here. There are two elements to this, in my opinion. Firstly, there's your own fees, and secondly, there's your client's liability and outlays. And I'll deal with both these matters later on, but what I'd say in the meantime is that expenses become proportionally more important the lower the value of the claim. So they're far more important in a simple procedure claim than in a high value ordinary action. And the starting point, I think, to consider this here is you need to be aware of the law about expenses in small value simple procedure cases, because it's important. I'm not aware, I have to say, of any impact that the COVID legislation has had on any rules about expenses. And the rules, the law about expenses, as far as I'm aware, is predicated upon the procedure being as it was pre-coronavirus. So, for example, there's rules in there about travelling time, but there's not anything in there about the time that you may have to spend in helping a witness get connected up to the internet. So the rules about expenses are not yet caught up with the realities caused by coronavirus. The starting point for looking at expenses is the Actus Sederunt Taxation of Judicial Expenses Rules 2019, which came into force on the 29th of April 2019 and which apply to actions raised after that date. The Act deals with witnesses, fees and outlays. Regarding fees, there's a table under Schedule 5 which uses units of £16.40. So, for example, we're told that you're entitled to a fee of 32.5 units to prepare for a proof. Conducting a proof is 1 unit for every 6 minutes. So that's £533 preparation and £164 per hour to conduct a simple procedure proof. But although that's not bad, it gets worse because there's provision for charges to be reduced by certain percentages. So this is in terms of Rule 3.7. So there has to be a 10% reduction. And then if the claim is for £2,500 or less, there's a 25% reduction. And if it's under £1,000, there's a 50% reduction. So it's not great. And if that weren't bad enough, this is all subject to another piece of secondary legislation, which is the Sheriff Court Simple Procedure Limit on Awards of Expenses Order 2016, which came into force in November 2016, and it restricts what's recoverable by way of expenses. So, for example, it says no award may be made if the value of the claim is under £200. No more than £150 can be awarded if it's between £200 and £1,500. And no more than 10% of the value of the claim may be awarded where it's between £1,500 and £3,000. So this order covers what would have been a small claims case, not exceeding £3,000. The order itself, although it makes these restrictions, it's subject to a couple of provisions in the Courts Reform Scotland Act 2014, first one of which is section 81.5 and the second of which is 81.7. 81.5 says that the restrictions don't apply where a defender, having stated a defence, has not acted in good faith, or where a party that could be a pursuer or a defender, has behaved unreasonably. So the restriction to no expenses, 150, 10% of the claim, these do not apply where somebody has not acted in good faith in relation to the defence or has generally not behaved reasonably. The second provision I mentioned, 81.7, is where the sheriff can disapply these limits if there's a difficult question of law or exceptionally complex facts involved. So there are these exceptions, if you like, which were also there under small claims expenses procedure as well. But you can see the different mechanisms working here. So there's restrictions and then exceptions to the restrictions, but the reality is, I think, that for something like a standard road traffic proof under simple procedure for under £3,000, you are going to be severely hampered in how much you can recover. All right, there's an advantage that your client's exposure to liability for the opponent's expenses is limited, but as far as your own position is concerned, you're not going to recover very much by way of expenses to cover your fees. So say, for example, you run a proof, you client wins, gets an award, principal sum of £1,000. Well, the most you can recover in expenses there is going to be £150. And that's it. Now, you might say, well, does that £150 cover fees alone, or does it include VAT? Uh, does it include outlays? Are these in addition? Because after all, the warranting fee is going to be £106. So if you take that off 150, you're left with under £40 plus VAT towards your fees. Well, the 2016 order is ambiguous, which is why there have been conflicting Sheriff Court decisions on this. And of course, none of those decisions is binding on whichever sheriff or summary sheriff you will next be appearing in front of. These are simply Sheriff Court decisions. They're not binding on anybody. The cases that I know about are as follows. The first one is a case called Gowans versus Miller, which is a case from Forfar Sheriff Courts reported on the Scottish Court Service website. It's a 2017 case. And in that case, the sheriff held that the limits were inclusive of outlays. In that case, she awarded the sum of £218.45, which was 10% of the value of the claim, and she said that that included VAT and it included outlays. So that was that decision. On the other hand, in the case of Martin against Southern Rock, which is a case from 2018 from Edinburgh Sheriff Court, the sheriff took the opposite view, and that was a road traffic case where the sheriff awarded a sum in expenses plus VAT plus outlays. And in that case, the agent for the pursuer referred to the Gowans case, but also another case, an unreported case from Aberdeen Sheriff Court called Ashley Potter against OSC Group UK Limited, which is a case from 2017. And in that case from Aberdeen, the court took the view that VAT and outlays were additional. As far as VAT's concerned, there is a set of cases from 2017 from Edinburgh Sheriff Court in which Sheriff Mackey held that VAT is recoverable on top of inclusive fees because, as she said, VAT is a charge imposed by statute on the cost of legal services supplied in the UK. So it's an integral part of fees. And it's something that has to be awarded in addition to inclusive fees. But the position, as I've indicated, is rather unclear. In May 2018, the Law Society of Scotland issued a consultation response in which it called for the 2016 order to be clarified. You can see why they would want it to be clarified. It certainly should be. In my view, it is rather surprising that there is this ambiguity because exactly the same problems used to come up under small claims procedure. So one might have expected those making the rules to realise that there was no need for that to happen again under the new rules applicable to small claims. It's a simple procedure. But the fact is that the problems are there. My own experience is that there are differences in approach, differences in opinion between sheriffs. Generally, I have found myself that the limit is taken to include VAT and outlays. So you have to raise the point. You have to try and argue it with the sheriff. But there's a lack of consistency. For example, I conducted a simple procedure road traffic proof in Paisley Sheriff Court on the 26th of October 2018, where the claimant lost. and the respondent was awarded expenses of 10% of the sum sued for. Now, the sum sued for in that case was only £2,800. So the not the defendant, the respondent, is the term we have to use. The respondent got £290 all in, which included VAT on his lawyer's fee. Nothing was said about outlays. So that's what happened in that case in Paisley. On the other hand, I conducted a proof in Livingston Sheriff Court a year later, on the 29th of October 2019, where the claimant won and was awarded a principal sum of £2,393. He got expenses of £239, which is 10% of the sum awarded. Plus, he got outlays of £104, which at that time was a warranting fee. Nothing was said about that. Conducted a very similar proof in Hamilton Sheriff Court on the 8th of November 2019, so that's 10 days after the Livingston proof, where the claimant lost. The respondent in that case was awarded expenses of £150 inclusive of outlays. Now, I don't know whether the respondent had any outlays. None were mentioned, but he did have a witness who was there, who had presumably had travelling expenses. In that case, incidentally, the agent tried to have expenses awarded on the higher scale on the basis that the claimant's conduct was unreasonable. In other words, under Section 81(5) is it, of the 2014 Act, unreasonable conduct on the part of the claimant, but that was refused by the court. The alleged unreasonable behaviour, from recollection, was that the account given by the claimant was disbelieved. Well, there needs to be more than that generally. Something verging on improper or patently dishonest, I would think. So you can see that even if you achieve success in the proof, and even if the sheriff awards outlays and VAT on top of the limited sums referred to in the 2016 order, getting a decree for less than £3,000 is going to leave you with £300 at most to cover your fees for the entire case, which equates to less than 2 hours work, I would think, if you're charging a reasonable amount. The proof alone is going to consume more than 2 hours of your time, unless in exceptional circumstances. Having said that, of course, the suspension on the requirement of physical attendance for proofs has the advantage that you don't need to worry about travelling time, and your waiting time is likely to be far more significant as well. We've all had proofs that were set down for 10 o'clock in the morning but didn't start until 2 p.m. or later, meaning that you've been out of your office for an entire day. Chargeable time of 7 hours. Sometimes you're at court until the afternoon and then your proof gets discharged due to lack of court time. So there is considerable, or can be considerable, travel time and waiting time in court. And that's the same regardless of whether it's a simple procedure action, a small claims case, or a high value ordinary action. So at least the Coronavirus Act has had a good effect on reducing travel time and waiting time. So if I can go back to the question of expenses here, notwithstanding the savings made by coronavirus legislation, you can see that for claims for under £3,000, it's almost certain that it's not economical for your client to instruct you to conduct a proof. And clients need to know this. They need to be told about the economic realities. And they have to be told that at the beginning of your acting for them. And you have to be able to show that you've told them as well. So my recommendation would be that you have to put it in writing. I go further. I tell clients that it's not economical for them to instruct me to conduct a proof in a simple procedure case. Even one up to £5,000, it's not economical. And I recommend that they do the proof themselves. I do that in every single simple procedure case. And I emphasise to them that the procedure is designed to be used by unrepresented parties. Because we all know that a client is not going to take kindly to getting a bill for £1,000 plus VAT in relation to your fees when all he's been awarded by the court is a total of £1,800. It's different, of course, if there's a lawyer's bill for £1,000 plus VAT in a case where the client gets a decree for £18,000. Even though the work done by the lawyer, the time spent by the lawyer's skill and expertise is the same in each scenario. Clients nonetheless may want you to go ahead. Maybe they don't feel confident doing a proof themselves. Maybe they just want to make sure it's done properly, or they take the view there's a principle involved. There may be various reasons why they want to spend their hard-earned money instructing you to conduct a proof that the rules suggest they should do themselves. That can happen. You may find, however, in those situations that you do have to do some unpaid work. You may have to modify your fee quite considerably, possibly. You just have to take these things as they come. However, if you are going ahead to do a proof on behalf of someone in these circumstances, you do have to do what you can to keep the costs down and minimise the time involved in conducting the proof. And of course, you have to avoid cutting corners as well. You can't do an inadequate job just to save money. You do have to try and be as efficient as you can. I'll maybe come back to that later on, but in the meantime, I want to move from fees to the question of outlays. And the most important thing about outlays is that you have to make sure that you have got adequate funding to meet any outlays that are involved in running a proof, or indeed running any case to any stage, which means having money in your client's account or having cover from an insurer. Some of the outlays, some of the costs in running a proof, as you'll know, are the personal responsibility of the solicitor. Now, one advantage that simple procedure has over ordinary procedure is that there's no shorthand writer, so you don't need to worry about the costs of a shorthand writer because they can be considerable. You don't have that worry under simple procedure, but you do have to think about the costs that will be charged by witnesses whom you cite. And bear in mind that the witness costs are in many ways going to be the same regardless of whether the claims for £1,000 or £50,000. In theory, of course, you could have a proof under simple procedure or indeed under ordinary procedure where you won't have this risk of having to pay witness expenses. You may not have cited any witnesses. The witness may agree to attend voluntarily. Your client might be the only witness, or you may simply not have any witnesses. I once conducted a summary cause road traffic proof in Edinburgh, where liability was admitted, quantum was not admitted, and my task at that hearing was simply to cross-examine the opponent, the pursuer, and his accountant witness. It was a case where there'd been a collision between two vehicles. One of the vehicles, the pursuer's vehicle, was a private hire car, which had been rendered unroadworthy, and the pursuer, the private hire driver, was claiming loss of earnings, and he produced accounts which appeared to me to be grossly inflated, brought along his accountant, and My task, as I say, at that proof was to cross-examine the pursuer and his witness, challenge the veracity of the accounts, and I was successful in that. Managed to get quite a lot knocked off the award of the claim. Now, at that point, I had no witnesses. I didn't even have the client there, and that was fine. So, no need to worry about witness expenses in that situation. As far as witness expenses are concerned, the 2019 Act of Sederant that I've mentioned governs the amount that's payable for actions raised before April 2019. The relevant Act of Sederant, by the way, is the Act of Sederant Fees of Witnesses and Shorthand Writers in the Sheriff Court, 1992. But the relevant part of the 2019 Act of Sederant is Schedule 7, which is headed up reimbursement of witnesses. It says that a party to proceedings at whose instance a person is cited or requested to attend is liable to reimburse losses and expenses in accordance with paragraph 2. It makes it clear in the Act of Sederant that only a skilled witness is entitled to a fee. Paragraph 2 says that a witness, a general ordinary witness, is entitled to recover no more than £400 by way of financial loss, plus reasonable expenses for travelling, subsistence, board and lodgings. The £400 limit was also the limit in the 1992 Act of Sederant. An advantage, of course, of coronavirus legislation is that ordinary witnesses are unlikely to have any travelling expenses or board and lodgings costs or subsistence because they are not physically coming to court. They may have to go somewhere else, of course, to access the internet, but they don't have to come to court unless the sheriff tells them to, which, as I've said before, I think is unlikely to happen. So those are ordinary witnesses. You'll appreciate that there's a major difference between ordinary witnesses and skilled witnesses, because only the latter, only a skilled witness can charge a fee. Skilled witnesses, well, to qualify as a skilled witness, the witness has to be certified as such by the court. And if he's your witness, you have to make sure that you ask for that. Don't forget that, because that can be unfortunate. It can be a costly mistake. And what you should do also is apply to the court early for certification. One of the great improvements made by the new regime when it comes to expenses is that you get your skilled witnesses certified before you're incurring the cost of engaging them. Under the old procedure, of course, you're looking for retrospective certification. And of course, you ran the risk that you wouldn't get that certification and you're getting a huge bill from a witness and you weren't able to recover that. This system we have now is much better because if you don't get the certification, you can say to the client, we won't be able to recover the cost of this witness. A much better system. But as I say, you have to remember to ask for certification and do it at the right time. Certification will be granted if the witness is skilled and if the court thinks that it is reasonable and proportionate that the witness was employed. This is Rule 5.3 of the Act of Sederant. Reasonable and proportionate. This requirement of proportionality means, in my opinion, that you should not generally be having witnesses certified as skilled in simple procedure unless they are absolutely vital. And even then, do you have to bring them along, or can you not lodge a letter from them, or a report, or an affidavit, or something of that nature? This business about proportionality, I think, is really important. the old rule, the 1992 Act of Surveillance, just talks about it being reasonable. But this introduction of reasonable and proportionate, I think, is quite a significant thing. There haven't been a lot of cases under to determine this, but I think there will be, and I think that the requirement of proportionality is something that will be judicially examined very soon. But you have to really bear that in mind that small value cases may not justify a large bill payable to an expert or a skilled witness. Generally, for dealing with all witnesses, I said there's this cap of £400. You have to deal with a situation where an ordinary witness, sends you an astronomical bill for having been in court or having had to take time out to attend electronically. The witness, although not a skilled witness, might be someone who works and earns a lot of money or claims to earn a lot of money and might send you a bill for loss of earnings. And of course, as I say, if you cited that witness, you're personally liable. And the witness is almost certainly going to look to you before he looks to your client. Again, when it comes to risk management here, you have to just be mindful of the rules and mindful of the fact as well that the witness won't know about those rules, and you have to tell the witness or the potential witness about these costs and about these risks. You need to tell your client, and you need to be able to prove that you've told your client that a balance needs to be struck between bringing in as much evidence as possible and minimising the costs of running the proof. Explain all this to the client, let the client decide. The key to it, of course, is good communication. Don't call witnesses you don't really need to call. Recognise everybody thoroughly so that you can ascertain how good they're likely to be. You don't always know. Some people, they talk a good game in your office. They don't come over very well in the witness box or in front of a computer screen. Other people are very reticent, very quiet in your office, and are actually very good in the witness box. Maybe it's being under pressure makes them more vociferous in what they say. You never really know until the day. There's limits to how much you can judge these things, but you have to be thorough in your recognition and just in your assessment of how the witness is likely to be. So, as you discuss all this with the client, discuss the costs and the logistics and so on with your client's witnesses. Do it as early as you can. Certainly do it in advance of the attendance, whether it be a physical attendance or remote attendance. People you'll find generally don't like going to court. Nobody likes going. I mean, lawyers don't like going to court generally. Members of the public certainly don't in general. Nobody wants to be exposed to the spotlight in the witness box, being cross-examined, being called unreliable or incredible. If people can put you off calling them, quite often they will try to do that. Usually it was because of the fact they couldn't come to court because they had a job to hold down or they had childcare issues. Now you will probably find that they say they can't cope with the technology, or they don't have a laptop or an internet connection. You may find that there are now new reasons why people say they don't want to give evidence. You just have to find out about these issues as soon as you can, discuss them with the client, and just try and find some pragmatic way of dealing with the issue. Another thing I would just mention is interpreters. The responsibility for instructing an interpreter rests with the party. McPhail says it's up to the court to decide whether the interpreter is necessary. But it's not up to the court to arrange an interpreter. You have to do that. So again, it's another issue you need to consider well in advance. Does the witness need an interpreter? Consider also, do you really want to incur the costs of bringing along an interpreter? See if you could maybe dispense with that witness. I mean, you may not be able to, of course, but equally, you might. And bear in mind also that having an interpreter in a proof slows things down, because you ask a question, the interpreter repeats the question to the witness gives the answer, the interpreter has to interpret the answer. It all takes time, and I would expect that it would take even more time and be even more cumbersome if that were being done remotely. So time is money when it comes to proofs, particularly simple procedure, low value proofs. So see if you really do need an interpreter. Just look at that point. Could the witness lodge an affidavit? Is there some other means of getting the evidence? Just consider these matters. During the course of this talk, I've focused predominantly when it comes to outlays on the question of witnesses, because they represent the biggest expense that you will have. Proof obviously is taken up mainly of oral testimony, so witnesses will consume most of the time that's involved in running a proof, and their expenses could be considerable as well. So there's a major factor there as regards outlays. I want to turn, and you'll be pleased to know that I'm going to be finishing shortly, but I would like to turn before I finish to the question of documentary evidence. This requires a bit of preparation to deal with the logistical issues that might otherwise arise. The best thing, of course, that you can do is agree documentary evidence. But of course, it has to be in your client's interests to do that. And importantly, you have to have instructions to do that. You can't go off on a frolic of your own and agree evidence. You need instructions. You can give advice, and if you get the instructions to go ahead, you can agree the evidence, but you can't do it off your own bat. And the advice that you give will obviously depend on whether you think it's advantageous to your client to agree the evidence. Of course, under simple procedure, you may well have an interventionist sheriff who more or less tells you to agree the evidence, which in a sense is good in that it will save you a great deal of preparation and organisation. Unless a production is probative, in other words, self-proving, for example, a will, you need a witness there to speak to it. I'm turning now to evidence that's documentary evidence that's not agreed. So how do you deal with that? How do you have a witness speaking to a document remotely? In other words, a situation where the witness isn't even in the same building, never mind the same room as the production. Well, I think the answer to that is that you send the witness a copy of the production and get the witness to identify it by holding it up to the camera, and that ensures that everybody can see what the document is and everybody's working from the same hymn sheet, as it were. There'll obviously be an additional cost of doing this, because you'll have to take more copies of the productions. You wouldn't generally send copy productions out to everybody, but you have to do that to some extent here on the remote procedure. Again, preparation is critical. Make sure that the witness has the copy production before the day of the proof, long before. For one thing, you want to make sure that the paper material is quarantine, as it were, for 72 hours before anyone looks at it. So send it well before the date of the proof, and maybe contact the witness in advance to make sure that he has the material and will have it available for the remote hearing, and has the right material as well, because you probably know this, but you quite often get situations where a witness in a witness box has to look at a big bundle of documents and they get mixed up between the pages and things fall out and they're rummaging around and everything takes a long time. And I imagine that would be exacerbated under remote conditions as well. But just make sure that the witness has everything and it's in order and it's accessible and it's in a user-friendly form. So I will bring this talk to an end. I hope that some of what I've said has been helpful. COVID legislation means that you will be spending more time in relation to some preparation work and less time in relation to other areas. So, as I say, you'll be spending more time organising the witnesses who are giving their evidence remotely, but you've obviously got less time to worry about in terms of travel time and waiting time as well. Regardless of whether you're conducting a proof under COVID restrictions or not, the key is always good preparation as early as possible. And that is the way to run a proof as efficiently as you can and to avoid problems on the day and complaints down the line and problems about recovering expenses and recovering fees. The talk that I've given, I think, is very much at its time. It's the very end of October 2020, and the rules under which we have to operate are undoubtedly going to change, depending entirely on how the pandemic progresses. I would fully expect to be updating this talk probably in under a year's time, and one hopes that by that point the coronavirus pandemic will have subsided. But I hope, as I say, that what I've been saying to you has been helpful, and I would look forward to updating you in due course. So, as I said at the outset of the talk, in order to claim CPD, you will have to be a member of the Scottish Law Agents Society, a current fee paid member, and you should send your roll number by email to the address which you can find on the website, whereupon you will be sent a questionnaire and an opportunity to give feedback, and that is the means by which your CPD is verified. So if you do that, you will be able to obtain CPD for having listened to this talk, and I hope that you're able to look at some of the other talks that the Scottish Law Agents Society is presenting and is going to present throughout the course of the current practice year. If you have any useful input in terms of commenting on anything that's been said, if you have any experience of undertaking proofs under COVID restrictions that could in some way improve the quality of the talk in terms of expanding it, please get in touch. I'm always keen to hear about other people's experiences, and given that these are unusual times, it's great to have feedback from people who've conducted proofs under these normal conditions. I've certainly spoken to agents who have conducted proofs in various courts throughout Scotland, and it's extremely helpful just to find out what current practice is and how it's evolving, and how flexible practitioners can be, and how flexible the courts are as well, in trying to ensure that we get through the business, because that's what we're all trying to do. So, anyway, I shall say goodbye, and I hope that you have enjoyed this talk on behalf of the Scottish Law Agents Society. Thank you.